All right, folks, it is time for our favorite podcast, Cut to the Chase. And we're going to cut to the chase. Bringing on Kimberly Adams. How are you doing today, Kimberly?
Doing great. Thanks for having me.
All right, so we had Kimberly on over a year ago on 2 episodes of campaigns, legal campaigns that she was starting. Interesting campaigns, not your regular type of lawsuits. And so it's over a year later, or about a year later, and I wanted to get updates. Kimberly is a shareholder of Levin Papantonio. Levin Papantonio is one of the most prominent law firms in the world and has done a lot of very interesting work. They not only do just your regular kind of, hey, the FDA recalled some defective product and representing all these people that have been injured by the defective product, but they are trailblazers. Fred Levin, may he rest in peace. When the law didn't support his efforts, he got the state to change the law, and Florida recovered lots of money for expenses that they paid, dealing with cigarette smokers and all their injuries. Kimberly now is doing these 2 campaigns that I find very interesting. One against the pornography industry and one against sex trafficking. She's trailblazing. These are not cookie cutter kind of cases that slam dunk. The law is definitely, says what it means and means what it says. She's trying to put it all together. So we're bringing her back to talk about these campaigns and getting updates. You ready to roll, Kimberly?
Ready to go.
All right, so let's talk about the Pornhub case. Let's just remind, I know all my listeners here, they know every episode, they've listened to multiple times, but I want to remind them, give the skinny on what the case is, the campaign is, and then we'll get into a little bit more of the details and where you're at.
Right. Okay, great. So thanks again for having me on. We filed a case against MindGeek, which is the owner operator of the largest pornography site, or one of the largest. Unfortunately, there's more than one pornography site, which was Pornhub. Our case is not to take down pornography sites, right? Our case is against the trafficking and dissemination of pornography of minor children. And so when we filed this case, we have 2 Jane Doe minors that who were, I won't kind of give all of their background, but essentially were the subjects of a rape and or trafficking situation, to where they were forced into making these particular videos. And because at the time of the lack of prevention on the Pornhub website, were able to be disseminated amongst thousands and hundreds of thousands of viewers, likes, clicks, payments, those sorts of things. So our lawsuit essentially says we want injunctive relief to prevent minor children from accessing pornography, and to prevent minor children or anyone who is non-consensual from being exploited on those websites. So, we see, I forget how many thousands of cases have been reported to NCMEC, which is the processor of pornography against children, or children involved in pornography, unfortunately. And so we know that there's lots of means and mechanisms. There's something more than just a check the box. At some point there wasn't even that on those websites. And so kids could access it, and or traffickers could create accounts, and then they could post these videos that got disseminated over and over and over again. So I think that we're hopeful that our injunctive relief, we know that they've already made some progress in trying to prevent dissemination of non-consensual or CSAM, child pornography, on their sites, but we've got a little bit ways to go, I think.
So what has their position been in the litigation?
So their position in the litigation is essentially, A, we wouldn't have known this was a child, or B, we couldn't have known this was a child. We are a platform that's essentially operating as a publisher of information. We didn't disseminate it necessarily. This was some bad man that did those sorts of things. And our response, of course, is you set up the algorithms, you create taglines, you create categories. If we go on and search for, at the time when we filed our complaint, we could search for particular terms that were indicative of child pornography, and those terms would then produce additional related terms. So your site shouldn't be permitting those things to happen. We know that they participate in the categories. We know that they review all the videos, or at least they allege that they review all the videos that are coming online. But for the volume of videos that's coming online and the number of people that are reviewing it, we know that that's probably a little bit of a fallacy potentially. I don't know that there's any way that they could actually review for the things that they need to review for to prevent these things from happening. So, at this point, they have denied the allegations to a degree. I do think that there is a genuine desire, hopefully, to prevent child pornography from being online, but there's a fine line because you're going to necessarily cut out some of your profits from doing that. So I think we're still going to be, it's yet to be determined how this is going to kind of play out and what stance MindGeek is going to take at the end of the day.
All right. So you're still, I mean, how has the judge been, has the judge indicated one way or another? Who is the judge?
So there's a couple of judges. There are multiple MindGeek cases that are filed. We filed a class action for injunctive relief, and then we filed with additional minors in the Northern District of Alabama in front of Judge Kugler. Behind us, there was another similar class action with another plaintiff filed out in California. Both judges have issued really great orders, I should say great, promising orders when it comes to immunity, which we'll talk about in a few minutes. But so far, both of those judges seem at least to understand the law. They understand why these cases are moving forward, or we're asking them to move forward. And I think that they're at least open to interpreting the law in the manner in which it was written. And that's been tough because in the past, it's been difficult to get over this internet fear or this publisher fear. To kind of take a step back, I want to say it's probably in the early 2000s, legislature put forward a statute called the Communication Decency Act, right? Section 230, we always refer to it as Section 230. In that Section 230 Act, it essentially said that online operators, service providers, could not be liable for publishing content of third parties. They weren't being required to police what other people were necessarily posting. We could all see how that was maybe at the time something that was beneficial. And I don't know that anyone really expected to see online move to kind of the horrors that we see now. The efforts to help folks commit suicide, the trafficking efforts, all the social media issues that we've seen. And so the court right now is grappling with what is publishing. How do you define what is a publishing tool, a neutral tool, versus what is a tool that's creating algorithms or other ways that would raise cause for some kind of cause of action, negligence or TVPA or otherwise, any of these causes of actions that we're looking at, or even the dissemination of child pornography. And so the court is grappling with how to interpret that immunity statute. Everyone sort of is grappling with it. In our opinion, it was never meant to protect folks online or otherwise who are profiting from child pornography. And that's kind of
the immunity issue. It sounds like somebody individually wants to, basically get protection from being sued or.
Well, they've won. So I know I've kind of bounced around a little bit, but just to, there have been a lot of cases over the years where as soon as you have an online platform, Google, anywhere, when Section 230 comes into play, those cases get dismissed. The Ninth Circuit ruled on a case called, it was a Google case, I want to say probably 6 months ago, where they said, look, this was something where a group was organizing through Google with an ISIS issue, not organizing through Google, but they were using Google to help drive traffic to particular websites. And the court said in the Ninth Circuit that those algorithms that help drive that traffic is potentially a neutral tool, that you need something more than just the fact that you're bringing these two parties together to help perform whatever kind of crime or criminal activity or other negligent activity that's going on. So in the Ninth Circuit, they said Google was not going to be held accountable because of Section 230. We have cases, MindGeek is one of them, that says, look, you're doing a whole lot more than just publishing neutral algorithms. And I'm not even willing to say that the algorithms that are being created are neutral. I think the Ninth Circuit may have gotten it wrong, but it just tells you with how difficult it is that they're struggling with this question. But in MindGeek and Craigslist, we have other online platforms that are actually doing more than just creating means to make your searches more efficient. They're doing things like creating columns and taglines, something that helps contribute to the illegal content that we're trying to prevent from coming on those sites. So it's splitting hairs. We're just having to be real careful and cautious in our drafting of our pleadings, making sure that our arguments are spot on with why these are different. And I think the courts are getting it. They're doing their own legislative history and research. The legislature has gone through a couple of iterations, especially when we flop over now to the trafficking question, which says, essentially in 2016 or 17, that if a website is involved in something that knew or should have known was trafficking, 230 doesn't even come into play anymore. And so that we at least know, we feel like we never felt like it did anyway. So we feel like this additional legislation was just solidifying and reaffirming what we've known all along, that Congress never intended to protect people involved in trafficking ventures.
All right, so before we shift over to the trafficking, is there any discussion with, amongst senators, legislators about strengthening 230 or perhaps, firming up some of its language?
There is something called the Earn It Act that's being tossed around right now on trying to kind of modify the language. The concern obviously is every time you have new legislative language, then you got to get your court system to catch up to the interpretation. And so at least for me personally, I think I have a concern that may delay our efforts unless it is crystal clear. And I don't know that we're going to be able to get legislature that's crystal clear that's going to take all of these considerations into account. And so now from our pornography case, and again, the pornography case, it could be someone who's at a, they have, I don't know how anyone knows how Pornhub works, but they have like these model hub accounts where they have these areas where folks are coming in, they're making videos by Pornhub producing those, and those go on the site. And then you have your sort of amateur, if you will, pornography channels. And that's where this dissemination question's going on. Understanding that some of those videos could have been the product of a sex trafficking ring in and of itself, right? That's an easy way for them to video a live trafficking incident where that person then is disseminated over the website. In MindGeek, if they have certain accounts and certain levels, and I can't get into all the details, those people are getting paid back a profit. So if I have a channel that's open and people are subscribing to a channel as me, John Doe, and I'm posting images and video of Jane Doe, then I'm getting a profit cut of how many times people view those videos. So it's a vicious cycle, I think, that's going around. You asked me, whether any additional legislation is going to help. I don't know the answer to that. I would hope that it would, but I'm just not overly confident that we're going to get legislation that's going to be able to take into consideration all the horrors that we're seeing in these online platforms. So I'm a little nervous about it.
Do you have any hope to settle the case in a way that you feel you'll achieve your objective?
I would hope that at the very least, we would be able to get this injunctive relief taken care of. I mean, these platforms make lots and lots and lots of money. And I think that the technology is there to help them do facial recognition. There's a technology to hash tag certain videos so that those videos don't make their way onto these websites anymore. Some of it they could have done. They could have probably done all of it a long time ago. And I'm just hopeful that at least for that perspective, let's get the protections up in place sooner rather than later. And I'm hoping that MindGeek sees that as well and wants to get that injunctive relief moving.
do you have support from advocacy groups or congressmen, people in
We
Congress?
do. We do. In fact, in our MindGeek case, our co-counsel is the National Center Against Child Exploitation out of DC. So we do have, and they help with a lot of legislation, drafting or analysis. There's a number of advocacy groups. Obviously, they all want to see more protections for our children or for people who are not consenting to these sex acts against them.
Okay, so you have mentioned sex trafficking as part of sort of this pornography issue, but you also have a different sex trafficking campaign going on in a whole different court.
We do. So we have some sex trafficking cases against hotel brands, major hotel brands, as well as Craigslist. We have a sex trafficking count in our complaint against MindGeek as well. You also see sex trafficking causes of action against Facebook, Snapchat. There's a lot of different avenues on where those cases are going. We've been litigating the hotel cases for quite some time. And again, we got into this litigation because we knew of minors who had been, or adults, held in hotels, against their will and being forced to have sex with Lord knows how many men or women coming in and out of the room. That level of volume only takes place because you have these online platforms that are driving traffic to those hotels and making that connection. And so our hotel cases are, they're slowly moving along. It's been, again, we've probably had 85 or 90 motions to dismiss. We've had motions for summary judgment. We're in the trenches, really battling this across the country. Some courts are really sort of mindful of how the statute was written. Our first big hurdle was whether or not the statute required actual knowledge or constructive knowledge. I feel like the majority of the courts now have realized that there should be, that the statute was written to only have constructive knowledge, that you knew or should have known that what was happening here was trafficking, and that you turned a blind eye to it and did nothing. Right. And you benefited from it.
All right, so that would be like the telltale signs. Hey, hotel, you need to instruct your employees that if you see X, Y, and Z, that's a sign of trafficking.
Train them. Yeah, don't take cash for a room for the hour. Don't take, a lot of times people say, well, especially your sex workers, right? They have a different perspective of this. They say that these things are putting them in harm's way because it takes away their ability to conduct their business, which is, we keep saying, well, it's still illegal. Prostitution is illegal in most of these states. But, it's still, we think, of the benefit to protect children and non-consenting adults. And the signs are very clear, in our opinion. When you see people coming in and out that are local, when they don't have a driver's license, or maybe they do have a driver's license, but there's a man checking them in every other week. You can see patterns of conduct. They have do not rent lists where you can see that things may have gotten out of hand in the past. We've got violent acts that are happening. You've got unregistered guests coming in and out the front door or the side door. So you have lots of condoms, for instance, in these hotel rooms, or people who say, don't come in my room for the next 3 days. And then when they check out, so you can obviously tag who was in that room, even if they're gone at the time. There's a ton of ways we feel like clear-cut signals that with a little bit of training could help prevent the next girl from being stuck there.
All right, so just to try to make it sense for the listener here, a lot of people think sex trafficking, Jeffrey Epstein, makes contact with a 15, 16-year-old girl, tells her she's going to be a model, drugs her up, and then, basically uses her or abuses her for sex, prostitution, stuff like this. Your lawsuit is really against the enablers, the hotels and the Craigslist that are basically the conduit to the traffickers actually having a place to go, having a mechanism to make their contacts and do their sordid activities.
Right, the facilitator, that's the statute, is you cannot benefit or facilitate, you cannot benefit from facilitating trafficking, a trafficking venture. So yes.
All right. So the sex trafficking case, it sounds like you're in different states, federal court, state court.
Mostly federal court. There are a handful of state court cases, but we are, I think, in 7, 8 different states.
And it sounded like some of the courts are going your way, some are going the other way.
I think the majority of the courts are going our way when it comes to defining the statute. Again, we brought our complaint alleged a standalone claim for what would have been a beneficiary or a damages type statute, right? That you can bring civil remedies. It was a civil remedy statute. What we didn't want to do was say, and in some cases, we think there is some criminal liability, right, on the operators of some of these places, but we didn't want to be forced into having the trafficker engage. I mean, that's traumatizing to the plaintiff. Our case for the civil remedies wasn't against the trafficker, it was against the facilitators. So we brought this standalone civil remedies claim first. So we got past that hurdle. Then we had to determine whether or not that knew or should have known constructive knowledge applied to all the elements within that civil remedy statute. So now we've gotten over that hurdle. So now we're kind of moving forward. Our claims start at the top. And a lot of people say, well, why didn't you just start at the local property of the employees that were working there? Well, in our opinion, it's the folks at the top that had all the knowledge, the training, the money, the ability, the resources, and the knowledge of how trafficking was widespread throughout their hotels. They were the ones that needed to implement the policies. They are the ones that implement policy on all kinds of other things within their hotel brands and their hotel chains. So that's where we've started. So our next discussion, right, is going to be, does this direct and or indirect liability reach the top? I think that's going to be what we've got to prove up, right? When we get to trial, that's what we've got to prove.
Do you anticipate having to go bring in the appellate courts eventually on this issue of constructive knowledge?
Yes, the appellate court is we already have an appeal pending in the Ninth Circuit on our Craigslist case. Ties into Section 230, but it also ties into this constructive knowledge case. And again, I hope I'm not confusing everyone, but you know, when we look at the civil remedies statute and then we look at the Section 230, there was a carve out, as I mentioned earlier, that says no way did we intend for immunity to apply when sex trafficking was at issue. Where the courts are torn right now is whether or not the online platforms should be under the same mens rea requirements as the hotel chains, which is the knew or should have known, or whether because of 230, you have to demonstrate actual knowledge before the immunity is released. And so we're in the Ninth Circuit battling, and that all ties to the civil remedy statute. And it's just, you know, where's the common? How are they interpreting it? I can't imagine there being an interpretation that would lessen and offer less protection against a trafficking victim. This is a trafficking statute. So in our mind, and what our argument is, there's no way that a court wanted to lessen the protections for a victim. But we're having to take it up to the Ninth Circuit to figure it out.
All right, so last question, same question as with the Pornhub case. Are you having any support, advocacy groups, people in Congress? What's going on with that?
100% advocacy groups are on board. They want to see this kind of be shut down as well. There's not a lot of congressional movement because the real interest right now, the real sexiness is the Section 230 and how that applies. From the TVPA question, I've not seen any major legislation that's going to alter that amendment. I think if nothing else, it's been expanded a little bit. So I think we're good there. The advocacy groups have been very helpful. Now we just have to figure out what our juries are going to think about these cases. I mean, that's a real concern because you've got women and children who were or women who are damaged as children who are now coming in front of a court in a civil action. It's not easy for them because they've not had, easy roads, explaining what trauma bond is, explaining why these women don't leave. It's like the battered woman syndrome. It's trying to get a jury to understand those things, which may prove difficult. I don't know yet.
All right. Well, listen, this is great updates, fascinating case, great work. A lot of folks just don't think that lawyers really do anything good. You, my friend, do good. And I know you're going to get great results. And I know you're going to come back with an update when you're ready on either one or both cases. I would like, I'm going to do a pretty lengthy show note for this show with some links. So, a lot of the information that you were given or whatever, we're going to try to get it on here. So some people that are maybe interested in this topic or whatever can get more educated. And that's all I got. I mean, is there anything I'm missing? Yeah, anything you want to add to this?
No, I think the links nope, I think the links are great. We really appreciate the support. Thanks for letting us get the word out, because I think that's important, right? I mean, I think people don't understand. This isn't like the claimant who's chained to the bed. This is something that is less, I don't know the word that I'm looking for. I think everyone thinks of trafficking as overseas, or they think of it as someone who's chained to a bed and nobody sees them for years and years and years. These are things that are happening in our backyards to our children. These are things that happen very easily on online platforms. And I guess my only last message is just watch your kids, get the Bark app, get the Canopy app, keep your kids off the all these platforms if you can, because these algorithms reach them every single day and they don't know how to escape it. And it's a very scary, very scary.
All right. It's a crazy world. There's a lot of crazy things going on. And, again, thank you for coming on. And that'll be it for this episode of Cut to the Chase. Kimberly, take care of yourself and your kids also. Don't forget about that.
Right.
I know you're helping everybody else out, but, we all got to look after our own as well. So again, yes, subscribe, rate, review. You got comments, questions, maybe about this topic. When I bring Kimberly back again, if you want her to focus on a particular issue, let me know. And that'll do it for this show. Okay. So everybody be safe.